everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today I am going to discuss about force and criminal force. Indian Penal Code is a substantive law that has all the offences and punishments stated in it. Indian Penal Code has 511 sections which are divided into 23 chapters, each chapter dealing with a different category of crime. Force is mentioned under Indian Penal Code in chapter 16, that is offences affecting the human body. Force is mentioned in section 349 and comes under the category of criminal force and assault. People are often mistaken by two sections, that is force and criminal force, which are both differently mentioned under Indian Penal Code, though they came in the same category. Criminal force come under section 350 of Indian Penal Code and is different from force. On the other hand, section 349 provides the definition of force, which is later used in understanding criminal force. In India, every day there is news of someone committing the crime of battery or assault or criminal force. There is a possibility that it happens every hour or even minutes, though they are less serious offense than rape or murder, but still affects the human body in one way or other. A person hitting another person is still committing a crime. As these crimes increased, there came the need to make it an offense and make law so that the number of these crimes decreased. Force under Indian Penal Code is mentioned as a person is said to use force to another if he causes motion, change of motion, or cessation of motion to that other, or if he causes to any substance such motion or change of motion into contact with any part of the other's body, or with anything which is wearing or carrying, or with anything so situated that such contact affects the other's sense of feeling, provided that the person causing the motion or change of motion or cessation of motion causes that motion, change of motion, or cessation of motion in one way or three ways hereinafter described, by his own bodily power, by disposing of any substance in such a manner that the motion or change or cessation of motion takes place without any further act on his part or any part of any other person, by inducing any animal to move, to change its motion, or to cease to move. Force can be better understood through illustrations, but if put in simple words, a person is said to use force when he causes a motion or change of motion or cessation of motion and bring that motion into contact with another body or belonging, or even affects the other sensing of feeling. Then the person is said to use force. There can be three ways in which force can be used. First can be his own bodily power, or by disposing of any substance, that is applying his bodily power in a substance and the substance moving forward, or by inducing any animal. In any of the three ways mentioned above, a person is said to use force even if a person induces an animal to move or affects the change of feeling of the person. The accused will be the person who induced an animal in the first place. It is not necessary to come into the direct contact of the person of commit force. It can be done without coming into direct contact. To better understand what force is, the difference between criminal force and assault must be clear. Criminal force is intentionally using the force without the other person's consent and to cause any criminal offense, or knowing that such force will cause an injury to the person, then the person is said to commit criminal offense. Whereas a person is said to commit assault when he makes gestures or any preparation and makes the other person think that he is about to use criminal force against him. In force, there are words that are not mentioned. There are that are intentionally, consent, offense, and injury. These words are thus used in the section after force, that is section 350. Force does not mention intentions or consent or injury. To be clear, section 349 is not an offense itself but used in later sections. This section thus misses the word like intention or consent or injury, as this section is to give a better understanding of what is force and how it can be used, and as discussed above, it can be used in three ways. So when force is used, it can be criminal force or even an assault. What is the judicial approach regarding this? To understand the judicial approach of force, how it is exactly related to criminal force and assault, we need to study a few case laws which will give us a judicial approach to force. Now I'm going to discuss about State of Bihar versus Musa Ansari. Around 9 a.m. the accused came into the first informant house, and there he was requested to sing a song, but after singing the song, the son of the first informant and her daughter both went to the school. The eldest daughter went outside for some work too, but the youngest daughter of the first informant was present inside the house. The accused still continued to sing and showed the pictures to the youngest daughter, but after a while the accused got her hold and made her hold his penis, and further told that he was feeling good because of it. Then he forcibly started having sexual intercourse with her and caused bleeding in her vagina. When the first informant came to the house and found her youngest daughter weeping and sacred, she further inquired and found out that the accused made an attempt to insert his penis inside the daughter's vagina and witnessed blood from the vagina. Thus the first informant report was filed and the further inquiry was made. The accused denied his doing and said that he was sarpanch and was building a boundary wall of his burial ground. Thus the Hindus have made these false accusations. The accused was charged with sexual section 376, but the judgment of session court held him not guilty and acquitted, that accused but convicted the accused with 253 and 354 in the session court. The session court made guilty of section 253 and 354 of Indian Penal Code. In the judgment, the court removed the charge of 253 by seeing the evidence and seeing all the ingredients were not fulfilled in the facts of the case, while more concentration was put on the section 354 of Indian Penal Code, as it deals with the outraging of women's modesty. Section 354 cannot come into the picture without criminal force and assault, and these cannot be in picture without force. Thus, to see the charges of section 354, section 349, 350 and 351 needs to come into the picture as well. In conclusion, I'd like to add that criminal force or assault are very common crimes that are committed in India. They are even neglected many times or just ignored. For example, a person is standing on the road and the next person standing with him makes a fist and make a gesture of punch. This will surely cause the fear in one's person, thus committing assault, but this petty thing will never be reported in the police stations. As we have already concluded, section 349 defines the word force, and thus it is followed by the other section mentioned in Indian Penal Code, such as criminal force. We need to understand that even if offense is not major as rape or murder, but still affects the human body and the seriousness of it, as these crimes are often neglected or even reported. Force and criminal force are two different things. Both are often mistaken as the same. In section 349 there is the definition of force, and while in section 350 it is mentioned how force can be used in a criminal way. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comments section, and don't forget to like, share and subscribe the channel. Let's click.